First up, I am Scott Schomer. I am a graduate of Boston University School of Law. I am a certified specialist in the areas of estate planning, trust, and probate law. I am the founder of the Schomer Law Group, as well as Schomer Wealth Advisors, a financial advisory firm. I've been recognized for 11 straight years running as a California super lawyer in this area, as well as having been designated a 5-star wealth manager, and I'm also a lifetime member of the Multi-Million-Dollar Advocates Forum, which means that I have taken matters to trial and obtained judgments in excess of several $1 million, almost all related to this area of law, trust estates, and whatnot. So that's who I am, but the firm is not just me, it's the Schomer Law Group. So next up is our associate attorney, Lauren Moritz. She's a graduate of the USC Gould School of Law and Chapman University, where she graduated summa cum laude. Member of the California Bar Association. Her focus of the practice is on trust administration and probate, estate litigation, and conservatorships. She was also recognized by USC as a trust and estate scholar. Proud to have her as a member of the team. In addition, we're surrounded by an incredible team of paraprofessionals, including our operations director, Caesar Gill, Courtney Andrews, Carla Calisord, and Kamani Bellamy. When you come and we help you, you'll find that you'll have a whole team that supports you through all these matters. Okay, so that's us. That's the Schomer Law Group briefly. So let's talk about probate and what the purpose is. So we start with the issue is we are transferring assets after somebody has passed away. We are doing post-mortem administration, asset transfers after death. And if you're dealing with it, you'll see in California, there are 5 basic ways to handle asset transfers. One is automatically by the form of title. The most popular form that's known out there is joint tenancy with the right of survivorship, but there's also community property with the right of survivorship. The second method is by contract designation or beneficiary designation. The third is by transfer on death statutes. The fourth way to do this is by probate. And then finally, the fifth way to do asset transfers at death is via a living trust. So the focus of our seminar today is exclusively in category number 4, probate transfers, which are really the least efficient and the most cumbersome way to transfer assets. In fact, when we do estate planning, what we typically do, the way we typically describe it is we're engaging in probate avoidance. The whole goal is we want to stay out of the probate court. So why do we want to stay out of the probate court? That's the purpose of today's seminar. We're going to go through some basics. So the purpose of estate administration is to conserve assets, protect creditors' rights, and distribute the assets according to the plans of the decedent or the person who has passed away. So the first issue that we face is, are there assets that have not been dealt with in any of the other 4 methods of transfer? So assets that are inside of a living trust don't have to go through probate, typically. Assets that have joint titling typically don't have to go through probate. So our first question is, do we have probate type assets? Once we get to that question, for instance, perhaps we have a bank account, let's say with either 100,000 or 200,000 in it, the next question becomes one of materiality or the size of the account. So do we need to engage in a full probate administration, or can we do it by means of the summary administration, also referred to as the Small Estate Administration Act? So with smaller estates, you can present a declaration if they are $150,000 or less. You can present a declaration to a financial institution along with the relevant documents, which would include a death certificate, a will if there is one, and a declaration that says that you're the person who's entitled to receive these assets. And under the Small Estates Administration Act, which is found at Probate Code 13100, the financial institution is empowered to pass the assets along to your loved ones without engaging in formal court proceedings. If you cross that threshold, so if the assets exceed $150,000, or there's any sizable real estate in California, then what you're looking at is a full estate administration. So full estate administration, what are our basic steps? So our step one is the appointment of the personal representative. What is the personal representative? Personal representative is a blanket term for the person who's going to be in charge. They are the people that are going to be stepping into the shoes of the decedent. The title they have depends on the circumstances of the case. So you're probably most familiar with the term executor or executrix. That's a person who's named to serve as the personal representative in a will and is willing to serve in that capacity. So if you have a named person, they are the executor or executrix. If there is no will, or if the person is not named, then what you're looking at is you're looking at an administrator. They are essentially the same position. This personal representative is going to be in charge of the estate and running the affairs. It's just simply that they have different titles under probate nomenclature. So while you're thinking about this, and if we're looking at probate, choosing a personal representative is a very important decision, whether you're doing it pre-mortem, in other words, before you die, when you write a will, or you're doing it post-death. So really, this person is going to be your alter ego. They're the one that's going to be in charge of dealing with the technical duties. They're going to have to inventory and appraise the assets, or arrange to have them appraised. They're going to have to collect debts. They're going to have to supervise the preparation and filing of tax returns. They're going to have to supervise the preparation and file accountings. They may have to operate a business. They may have to sell and liquidate assets. So give some thought as to who you're choosing. Is the person you're choosing honest, capable, able to do something like this? Do you have a complicated business that requires a special level of expertise? These are all thoughts that you want to give to this decision before you make an election as to somebody serving in your personal representative, because being a personal representative is a large job and it's stressful. So why would you, for this situation, want to name an individual? Well, the advantage of naming an individual is that typically somebody's going to have personal knowledge of your family, and often they're going to have a vested interest. They're going to be committed to help, especially if they're a beneficiary or a caring loved one of somebody that you're leaving assets to. The disadvantages of choosing an individual executor is that they may lack the technical skills or knowledge. They may have a hard time making difficult decisions. Do we sell the house, not sell the house? Oh, in order to sell the house, we have to get the tenants out, which means I have to evict my niece or my nephew. Is that person going to be able to step up and do those types of things? And the person you pick may not want to be bothered, or may be gone by the time the responsibility comes around, and they could refuse to serve. So another option is to consider using either a corporate executor or a private professional fiduciary, an individual that's licensed under the state. So there's a number of advantages. One is that they're going to have tax and legal advice. They're going to have some permanency. They're going to be often known to the court. They're going to easily be qualified, and especially in the case of a corporation, they will often have deep pockets to ease your mind about mismanagement of assets. The disadvantage is that some of the professional fiduciaries, especially the corporate ones, may charge higher fees and may not have a lot of sympathy for your family, especially if you have sensitive beneficiaries who are going to be receiving the money. Individual versus corporate, a friend or relative is going to keep a family involved, but a corporation is going to be able to bring in-house often the tax and legal skills, the ease of qualifications, and the deep pockets, all of which are a benefit. There's not necessarily the right answer here, but these are all things that are important to consider when you're considering who's going to serve in this role. Now, the role of the personal representative is a fiduciary role. It's the highest responsibility that's recognized under California law. It requires a high degree of good faith and a high standard of care. You generally cannot engage in self-dealing. You can't help yourself to your share of the estate first. You have to be very cautious. If you're going to make a decision that has impact on other people, it's often wise to go seek the buy-in or the consent of the other beneficiaries before you make that decision. And the role of the personal representative is transmitted through documents that are referred to as letters. You may have heard of these before: letters, testamentary, letters of administration. If you've not seen them before, what they look like is a court order. They are generally one page. Sometimes they are several pages, but it's simply a statement that we have appointed your friend Joe Blow or your son Bob Jr. to be the executor or administrator, and that under the law gives him or her the power to be able to go and act. But the most important thing is that they're going to want to have a high standard of fidelity. So how is a executor or administrator appointed? Well, you petition the court. You file essentially a lawsuit. Probate is essentially a lawsuit. So if it is Bob Jones that has died, somebody who's an interested party petitions the court and says, Bob Jones is dead. He died on this date. He died in this location. And here's the person that we would like to have take over the estate, Bob Jones Jr. If all appears in order and the court either recognizes the fiduciary appointment in the will, or the person has priority, then the court will appoint the executor or administrator, personal representative, and issue the letters allowing the administrator to get started. Okay, so that's a summary of step one. Is you have to file the petition, you have to file the lawsuit, and you have to seek and obtain letters of appointment. So then the next step is notice to creditors. So what are notice to creditors? Well, the simple rule here in probate is you can't take somebody's assets without first paying their bills. Kind of a basic rule. And in order to do that, what we want to make sure is, because we are concluding once and forever the financial life of the deceased person. So if there's somebody out there that has a claim, we want to make sure they know about this. We want to make sure they get their claims in a timely manner and that the claims are dealt with. So that's why we give notice to creditors, and that's why we have a limited time window, 120 days, for creditors to file claims. So you publish notice according to the law, you notice of the appointment. The administrator is required, the personal representative is required to generate a list of people that potentially have claims that they know of, send them notice with a form that allows the creditor to file a claim, request that the creditor file the claim promptly, and request that the debt be addressed in a timely manner. So that's the creditor claim period. That's a whole nother step, a whole nother seminar. We can go into detail on that, but just so you have the basic idea. The next step is the personal representative has to deal with inventorying of the estate. So again, the whole purpose here is that the administrator is taking over from the decedent and following either the decedent's wishes or the law of intestacy and trying to transfer the assets to the intended beneficiaries. But before we do that, we have to know what the assets are. And that's where the inventory of the estate is. So the first role at this step is that the administrator goes out and marshals all assets. So we start with some very basic things such as monitoring mail, and we see what types of account statements come in. Are there account statements being submitted? Are there bank statements laying around the house? Is there evidence that the decedent banked at Wells Fargo or Bank of America or Chase or at Charles Schwab? We want to know that, and the personal representative then wants to approach these institutions with his or her letters and attempt to find out information on these accounts so that they can be listed and included in the probate estate. So once you have this information, you prepare a judicial counsel form, an official court form. It's called an inventory and appraisal. Once that inventory and appraisal is formally filed, and I'll talk a little bit more about that in a minute, then it is eventually filed with the court. So there is a written disclosure as to what assets the decedent had in his or her possession that are probate assets at the time of his or her death. So we're looking to itemize all the assets that are held at death. That includes cash and bank accounts. That includes the contents of any safety deposit box. That includes receivables. So if there's debts owed to the decedent, that's listed. That includes patents and copyrights. That includes business interests, LLCs, corporations, partnership interests. That includes insurance proceeds that are payable to the estate. In other words, they don't have a named individual as a beneficiary. And then finally, of course, real estate. That's something else that has to be inventoried and appraised. So assets that are not subject to inventory appraisal are those that are basically avoiding probate. So joint tenancy assets. Joint tenancy assets avoid probate and they do not have to be reported in the probate estate. Tenancy by the entirety, assets held that way, same effect. Assets that are inside of a trust, they do not get reported in the probate estate. Assets that are passing by contract or by the death statutes. So if there's something that says I have an insurance policy, but rather than leaving it to my estate, I leave it to my friend Sam or my friend Susan, then those assets go directly to that person and they don't go through probate, and it's not required that you inventory them. Non-probate assets are only dealt with when they pay directly to a decedent's estate and there's no beneficiary that survives. So we've encountered this situation several times where the decedent will list my friend Joe as the beneficiary, but it turns out that Joe is dead and there's no named successor. So those would be the one occasions or the few occasions that you would inventory those types of assets. So inventory is part of the estate. You generally list the assets at face value. There's a duty to try to promptly collect them. Also to try to settle doubtful claims. And if necessary, if you think you have some fights or some claims, so in other words, there's somebody that's holding the decedent's assets, you should consider filing a lawsuit and pursuing the same rights that the decedent would have at the time of their death. And of course, if you're concerned about whether litigation is a good step or it makes sense to pursue, that's something you can always put in front of the probate court by asking for instructions from the court on what to do with a disputed claim. Okay, so step one we talked about, appointment of the personal representative. Step two was the notice to creditors. Step three was the inventory of the estate. Now we move to step four, which is appraisal of the assets. So one of the mistakes that I see happen from time to time is that administrators, especially non-professional ones, will think, oh, I can look up the value of real estate on Zillow, or my friend's an appraiser, I'll just have him prepare the appraisal. Well, no, there's very particular and specific methods by which assets get appraised inside of a probate. So the first thing is that you have to use a California court-appointed probate referee. A probate referee is an appraiser. This is a group of people that have years of experience and gone through training and applied directly to the probate court with their qualifications and said, I would like to be an appraiser on probate estates. Assuming they meet all those qualifications, then they're on the approved panel. And when you open up a probate estate, you ask the court, or the court appoints early in the case, a specific probate referee. This person is now your probate referee. That's the person that you have to use to appraise the assets. So what specifically gets appraised? Well, it depends on the asset. So for instance, cash generally does not get appraised because it's kind of obvious on its face. If you go down to Chase Bank and you discover a bank account with $350,000 in it, you can have a statement and pull a check out of the account that says that you're taking $350,000, putting it in the estate. That the the personal representative can appraise by him or herself. Essentially, it's not appraised. You just attach a copy of the statement. Just about anything else other than cash is going to be subject to appraisal. So that includes jewelry, that includes works of art, that includes collections, that definitely includes real estate, it includes cars, and the value of those assets is subject to court review. So that's step 4. So again, reviewing, we started with the appointment of the personal representative. Step 2 is notice to creditors. Step 3 was the inventory of the estate. Step 4 was appraising the assets. Then we moved to step 5, which is interim duties and accounting. Now, in reality, this is a duty that pops up almost immediately on appointment, but it's the type of thing that can go on. There are probate estates. Most of your probates will take about a year to a year and a half, but I've worked on several probate estates that have been open for a decade or more. And if you have an estate that's open that long, this is the type of ongoing duty that's going to be required of the personal representative. So interim duties include selling or liquidating assets, collecting rents or other income. So if the decedent had a rental unit or a duplex, the administrator can't just abandon it. The administrator has to go to the tenants and say, I've now taken over for the decedent and you should now be paying the rent to me. The administrator is going to be collecting that rent, depositing it in the estate account, and is going to be expected to account for every penny collected and every bill paid. The administrator also has a duty to invest cash, invest it in a safe and conservative manner. The administrator has a duty to preserve assets for distribution. So if you step into an estate and you discover, for instance, that the real property is in foreclosure, that's something that you have to do something about as personal representative. You have to preserve the asset. You have to stop the foreclosure. And of course, this is one of the many reasons that you hire lawyers to work for you in this type of situation, because you need all the advice you can get. If there's an active business, the administrator has to make a decision about how to handle that business and may need to seek either court permission to continue it or direction on how to handle it. And of course, with an active business, there's all kinds of potential responsibilities and duties, including the payment of lease expenses, employees, income tax withholding, all that type of stuff. The administrator has to honor contracts. The administrator also has to prepare and file tax returns and may be required to prepare and file interim accountings. One estate that comes to mind that I have right now is the estate is a multi-million-dollar estate, but there are 2 assets where the decedent had a small interest in partnerships that he doesn't control. The general partner has indicated he wants to sell these interests, sell the whole partnership assets, but he's not going to be able to do it for about 6 or 8 months. So in the meantime, what the personal representative has done after completing most of his duties dealing with the other assets is he's prepared an accounting and even asked to distribute some of the property to the beneficiaries. So this personal representative may have an ongoing obligation every year or so to render an accounting and just update the court on the status of administration. How is it going? What money has been collected? What debts have you dealt with? What bills have you paid? So on and so forth. Estate taxes. Some estates have estate tax issues. So first of all, the thing you need to realize is that the establishment of a probate estate creates a new taxable entity. You actually get an EIN number in almost all circumstances if you're holding assets. And the reason why is that the assets had been held by decedent during his or her lifetime. The decedent is passed, and now we have an interim period while the probate is being processed. And so there has to be tax reporting during that time period. And so the job of the administrator is to obtain an EIN, a tax identification number, collect the assets, pay the bills, and file income tax returns for the probate period. The administrator also may be required to address federal estate tax returns, or if you live in a state with state estate taxes, you may have to deal with it as well. Fortunately, here in California, we no longer have a state estate tax, but who knows what the future will hold. When you get to this area, when you get to tax duties and responsibilities, delegation is definitely permitted. You are empowered to hire accountants and attorneys and ask for professional assistance to help you with the performance of your job. Otherwise, the only people that would be executors would be CPA attorneys, most likely. So this is a place where you can go for assistance and pay appropriate professionals. Finally, you're going to want to deal with an accounting. So this is a complete record of all activities. This means formal reports on receipts and expenditures. It has to be reviewed by the court. One of the situations we often encounter in probate estates is that we will have an individual that believes in running their life on a cash basis. So they pay all of their bills. I've literally had estates where people go down to the Department of Water and Power and pay their water bill in cash and their phone bill in cash. Well, as an administrator, you can't do that anymore. If you're spending the estate's money, you need to be able to show where, when, and how it's spent. So if you're going to have work done on a place to clean it up, or hire somebody to help you, you need to pay in a manner that it can be traced and has receipts. So it's a much different situation than the way that many people run their lives. Eventually, the place we're heading is that the administrator is going to eventually want to file a final report, or a final accounting and report, seeking approval of all the administrator's work in the estate and asking for a discharge from the court for final responsibility. You can't get that without explaining to the court what assets you've collected, what you've done, how you've spent the money, and what's left over for distribution. So that's where you're heading. Okay, so again, step one, appointment of the personal representative. Step two is our notice to creditors. Step three is our inventorying of the estate. Step four is the appraisal of the estate assets. Step five is the interim duties and accounting. Step six is the estate distribution. So in order to distribute the estate, you have to prepare and file a petition to distribute the assets. It has to be filed with the Superior Court. And you have to give a full report to the court of what you've been doing as the personal representative for the last 9 months or a year or longer. You can only do this after you've addressed and paid any valid outstanding claims. You can ask to have the claims paid as part of the final report, but all of those things have to be addressed. If the court finds that you did your job in an appropriate manner, it will issue a decree of distribution and give you specific instructions on what to do with the remaining assets. So for instance, it might say, I want you to pay these last 3 bills or fees and costs, and then from the net amount, I want you to divide it into thirds, if the will had said divide the estate into thirds. But the court is going to give you a specific instruction on how to distribute those assets. Okay. So again, going back to our review here, we've gone through our 7 steps: appointing the personal representative, we give notice to creditors, we've inventoried the estate, we've appraised the assets, we've dealt with estate distribution and discharge of the personal representative. So what other actions might be needed? Other actions that may be required would include guardians for children, protection of children from litigation, and special processes for certain family rights. So for instance, if part of the estate gets distributed to a minor, somebody who's 10 years old, a 10-year-old can't legally accept money. So this may require that the personal representative have arranged to have somebody appointed to be a guardian for the minor, so that that person can hold the money that he or she is going to inherit and protect it and keep it safe until the minor reaches the age of majority. Same thing for protection of children for litigation or certain special processes for family rights. Now, one of the challenges, so these again are the summary of the 7 steps. So one of the challenges that we face, and one of the reasons we're not big fans of people who are doing planning going through the probate system, is the issue of estate shrinkage. There are a lot of expenses in settling an estate. Those expenses include settlement costs, the distribution of decedent's debts and payment of debts, the diminishment of the diminished value factors, liquidation factors, and taxes. So let me go through a couple of these just to give you an idea. First up is the payment of the last illness and funeral expenses. These are debts and claims that have priority under law. Somebody told me the other day they drove by a funeral home and said, "Drive carefully, we'll wait." Often it's because they know they're going to be paid first. So that's something that's going to drain an estate. Next is cost of administration. That includes the cost of bonds, the appraiser's fees, the estate insurance, the property maintenance, sales and commission, legal and accounting, and court costs. So the average cost of probate administration in the state of California averages between 4 to 8% of the gross value of the assets. Let me say that again, 4 to 8% of the gross value of the assets. So if you have a residence that's a probate asset that has $1 million in value, which is not unusual in California, you're looking at close to $55,000 in fees and costs just for the process of processing that asset through the probate court. All of these things contribute to the expense of probate, and the 4 to 8% is made up of the items that we have listed here: the cost of the bonds, the appraiser fees, the estate insurance, and whatnot. Okay. We also have to look at dealing with debts. When you open up a probate estate, the requirement that you give notice to creditors really is almost an invitation for them to step up and make the claims. Often we find that creditors are much more responsible or engaged, and they will get their claims filed, which means all of these things are going to have to be addressed in the probate estate and paid before any distribution. Of course, we have to deal with estates, estate taxes. That includes federal estate tax, state or inheritance estate tax, income tax, and property taxes. All those have to be addressed and dealt with through probate. Then, in addition to all those hard costs and fees, there's other things that are difficult to value and can also have a big diminished impact on the value of the estate. Those include the loss of management skills and the change of character of assets. So what do I mean by this? So first is the forced sale of assets to pay a lot of these costs. Look at the last illness and funeral, the settlement costs, the debts, and the taxes. The year 2008 and 2009 was a particularly painful period for a lot of the families that I assisted with this process, simply because there had been such a gigantic dip in the real estate values. So I can remember several cases where people came to me with real estate valued in the $300,000 to $400,000 at the time the decedent passed, and by the time we were able to get the property to market, the value of the property had diminished, sometimes by as much as 50% or more. Conversely, often the administrators find themselves having to sell at a difficult time of year to deal with these expenses, such as Christmas or Thanksgiving or the New Year holidays. All of those things can have an impact, whereas if you are not under the pressure of the court and of some of these debts to deal with it, you have a little more flexibility. Okay. So in summary, these are a big list of all the areas where the estate assets leak or your inheritance leaks or is diminished in a manner that I think is unnecessary. So those include executor fees, attorney's fees, trustees fees, accounting expenses, management and sales costs, court expenditures, debts and claims, federal income tax, state income tax, federal gift tax, and generation skipping taxes. All of these things can have an effect and can reduce the value of the estate and are part of the reason why this is not the most efficient system. With all due respect to my good friends at the probate court, all the judges and attorneys and clerks, assistants that work there, it is really and should be the system of last resort. You should really try to engage in probate avoidance.